48-hour notice as required under the Open Public Meetings Act has been met as notice this meeting was emailed on January 28th, 2026, and published in the Asbury Park Press, the Post-Star, and the Post-Star. Copies will be placed on the bulletin board in the borough office, and a copy is filed with the borough clerk. Mr. Bagley?
Here.
Chair Conan?
Here.
Councilman Hart?
Here.
Ms. Mahoney?
Here.
Mr. Mayor?
Here.
Councilman Nowicki?
Here.
Ms. Saracen? Here. Mr. Wishbo is excused this evening. Ms. Lady? Here. Mr. Frederick?
Here.
Mr. West?
Here.
And is on her way. And also present this evening is Michael Shafai, our board engineer, and Christine Bell, our board planner.
Great, welcome and thank you for attending the August 20th, 2026 Bradley Beach Land Use Board meeting. The board will observe a 10 p.m. time limit with no new applications or testimony started after 10 o'clock without the polling of the full board. If an application is not completed during the meeting, the continuation date will be announced by the borough attorney. We'd like to maintain civil environment for this public hearing. Request no calling out from the audience. Everyone will be given a chance to be heard. After the board and its professional staff have completed asking questions of a witness, the meeting will be open up to the public for questions only of that witness. This will be a time for questions only and not for comments. If you have a question, please raise your hand. I will acknowledge you and come up front. Before asking your question, please state your name and address and spell your last name. And direct your questions only to that witness. If a person from the public is represented by an attorney, he or she must speak through that attorney. All attorneys should register their representation at the board at the start of the hearing. After the board and its professionals have finished questioning the applicant and before the board takes action on any application, I will open the meeting up to the public for comments. This is a time to speak on the application. The same procedure I previously described for questions is followed, and all members of the public who wish to make a comment will be sworn in under oath by the court attorney. Please be aware that the applicant and their attorney have the right to cross-examine any members of the public who may make comments. Written statements or letters from individuals who are not present, petitions, or speaking on anyone's behalf is not allowable under NJSA 40:55D-10D. Written statements from the public cannot be accepted as they cannot be cross-examined. Public participation in this meeting will assist the board in making decisions. We hope that the public hearing and your attendance will be a rewarding experience for all. Thank you for participating in the process. We have resolutions.
We take her the minutes first.
Sure.
Everyone have a chance to read them?
Yeah, I read them. Everybody else?
May I put in minutes?
Make a motion to approve.
Thank you.
Second.
Ms. Mahoney?
Yes.
Ms. Saracen?
Yes.
Mr. Bagley?
Yes.
Councilman Nowicki?
Yes.
Councilman Hart?
Yes.
Ms. Lady?
Yes.
Mr. Frederick?
Yes.
Mr. West?
Yes.
Mr. Mayor?
Yes.
And Chair Cohen?
Yes.
Now we have the resolution.
We have resolutions number 2026-14, the approval of bulk variance for a fence in the front yard with conditions. Matthew and Juliana Baxic, block 80, lot 12, 27 and a half Atlantic Ave. Did everyone get a chance to read that? Pardon? Yeah, it was a little different because they were using the Fair Housing Act for their foundational proofs. And they did present proper record, and it is encapsulated in the resolution. The fence is 3 feet and not 4 feet. And there will be a revised plan. Michael, from your
They
office?
are working with their fencing contractor, they're gonna be submitting us a plan. I kind of went over the concept with them for where the limits are gonna be, and they're gonna be submitting us the plan from their fencing contractor, which I'll verify meets the conditions that we approved last week.
Great, yeah, the conditions were pretty exact in there.
Exactly.
That worked out well.
Yep.
Thanks very much. We can vote on that?
Make a motion for approval.
Do I have a second?
Second.
Ms. Mahoney?
Yes.
Ms. Saracen?
Yes.
Mr. Bagley?
Yes.
Councilman Nowicki?
Yes.
Councilman Hart?
Yes.
Ms. Lady?
Yes.
Mr. Mayor?
Yes.
And Chair Cohen?
Yes.
Thank you.
The second one is resolution number 2026-15, variance, expansion of a non-conforming use, and bulk variances for a second-story addition over an existing one-story. Lewis and Rosemary Curlico, Lot 63, Lot 18, 310 Third Ave. Again, that was a use variance, so, you know, the proofs were put on the record about the minimal amount of intrusion that was being created by the building. Anyone else have any questions or comments on that resolution?
I have a comment.
Sure.
Under the memorialization section, number 3, it talks about keeping signs in front order. Doesn't seem like that belongs to
It
this.
doesn't belong to me. Will you make sure you strike that? I should have done a global search for that. Number 3. Yeah, that was overriding a resolution.
Where was this? In the,
Yeah,
in back end?
Yeah.
Okay.
Thank you. That's what it's 13 is.
Any other?
Do we have a motion?
I'd like to make a motion to approve based on the amendments indicated by Mr. Backer.
Second.
Ms. Mahoney?
Yes.
Ms. Saracine?
Yes.
Mr. Beckley?
Yes.
Ms. Leahy?
Yes.
Mr. Frederick? And Chair Tony?
Yes.
Thank you. We only have one application scheduled for hearing this evening. It's LUD 26/04, and it's a bulk variance to retain the non-compliant driveway apron material. Where is it Avis and Christina Duggar, block 69, lot 9, 406 Second Avenue. The applicants are seeking a variance to retain the existing concrete paver driveway apron, whereas reinforced concrete is required.
Good evening. Yeah, no, they were sworn last month, but that's okay. Can you both raise your hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Your name, please, for the record?
Ricky Avis.
A-D-E-S, and your name? Can you spell your last name, please?
David, U-G-G-E-R.
Thank you.
Sure. Floor is
So,
yours.
as you noted, we're seeking a variance for a non-conforming apron of our driveway. There's a little bit of a background story here. I'm happy to walk through the facts with you or explain kind of how we got here today. Might be helpful. We purchased our home here in Bradley Beach in 2020. It was in need of some interior and exterior work. And we engaged a contractor, Mark Daly, a reputable contractor in the neighborhood, came highly recommended from residents here in Avon, to do the work throughout the home and throughout the exterior. One of the projects was a driveway project. We share a driveway with our neighbor. The prior occupants of our home had let our driveway deteriorate to an incredible extent, including feral cats living in the garage and trees growing out of the garage, and there was a chain link fence down the middle of the driveway because the prior residents had put so much, garbage out on the driveway that our good neighbor, who is no longer with us, put up the fence to keep the garbage from spilling into his side of the driveway. So when we purchased the home, we took down the rusty fence, we decided to pave the driveway, which was falling apart, and fix the sidewalk, which was also in disrepair, and the apron. Our contractor had previously handed all permits. We, for example, put in an outdoor shower, we got the permit for that, and we told him we needed any permits we needed, he should get, and we would pay for it. He didn't get a permit for the driveway. I think he was unaware that there was a permit requirement. I haven't spoken to him, so can't confirm that, but he acted in good faith and we have a project. Went ahead and put the blacktop on the driveway, and we agreed we put these pavers in as the apron because it was a pretty design. Suffice it to say that work was completed on about September 20th or 21st of 2020. A few weeks later, in October, somebody must have driven by and seen that there's some phones there. We completed the work and waited for the driveway to, I guess, cure. And we were told, oh, you didn't get a permit. So, gosh, we didn't know we needed a permit. We said we'd go get it. And we wanted to cure any, we were told we were in violation because we didn't have a permit. That was the stated reason that we were given. We went and said, okay, we're gonna get the permit, we'll cure that violation. And the person who worked, I don't remember their name, for the town of Bradley Beach, said, great, we submitted it, and we received the permit, and that was the end of it. So they had observed the driveway in its completed form, including the papers and apron, and we never heard from anybody again, and we felt we had cured our violation of not having the permit. And more than 6 years later, somebody indicated that we had been in violation of the variance, the town code requiring a full reinforced concrete apron, and that we were in violation. We explained the circumstances to the individual, told them, we had engaged the town in good faith and thought we had cured any problems with the driveway. The driveway was in good condition. It's been in great condition for 6 years. He was not moved, and we got the violation notice. And so, in researching how to deal with this, it was clear we got. Oh,
He, in discussions, also saw the permit that we had filed.
we shared that with him.
Yeah.
And then
Do you know the gentleman's name you're speaking of?
It was Sue the inspector, as I can go back and look at
whoever wrote us their
I can probably look, I got it before.
So anyway, we did our research, determined that we had a choice of either ripping out a perfectly good apron or seeking a variance, and we didn't see the real need to incur that cost, or that it would be any benefit to the town or the community to take out the apron. So we opted to get the variance. I think, as you'll see from the application we submitted, we also felt like this might be the cheaper route. That is actually incorrect, and if we had to do it all over again, we would absolutely have ripped out the perfectly good apron and put a new one in, because this proceeding has cost us almost $5,000, $5,300 to get this done. And I think the cost of replacing the apron would have been far less than that. So that's our application, and why we're seeking the variance today.
I do have one question. This is a shared driveway.
Yes.
Since it's a shared driveway, could another property owner, do they have a say in this?
Yes, here. This that was
Okay, they are not on this application for the variance.
I believe we were told we had to do separate ones.
Would this be considered two separate driveways, since there's a division between the middle? They have a shared apron.
It's a shared apron,
But there's a divide and a fence, and there's a
No,
clear
the fence is built.
delineation between the two driveways.
We put Belgian blocks down the middle
Like a
just to
curb
make it
between them.
easier for people parking.
It's also two separate block lots.
Yeah.
So it is, I believe it's two.
I would consider it
I
two
would defer
driveways.
to our attorney, but I believe it's two applications.
Did your next door neighbor also receive a violation?
She did. And she's good.
Those also, okay.
Yeah.
You're in the blue house?
Yes.
And you're in the white house?
And the neighbor did receive the
Yes.
violation? Okay.
But they are not participating in this.
Yeah, that's her, but I believe that she's obviously not, I believe she's waiting to see what happens with this.
I have two questions.
Sure, please.
Not clear, one picture looks like the sidewalk is concrete, one picture looks like the sidewalk is pavers, the sidewalk.
The sidewalk is concrete, it's a different color because it's fresh from that picture. That was taken on kind of the day that it was installed, so it's still like new cement.
Still curing.
It's still curing. It doesn't look like that today. It looks tan like the rest of the sidewalk.
And then my other question, in the town's ordinance is, it's not just that it has to be concrete, but it has to be reinforced concrete, very specific definitions of how you reinforce that. Was that reinforcement done underneath these pavers or?
The strength of those pavers is equivalent to a reinforced concrete. We see this often. It's not a structural issue. Usually when towns put an ordinance like this in, it's to protect the town from doing a costly repair or replacement of a driveway apron if they're doing work that's inside the right of way. Say you had to come in here and do utility work or change the grade of the road, sometimes someone can put a very expensive material in for a driveway apron and you don't want to be on the hook for something that's a little more costly than concrete. In this case, though, the town has already came in and went to about 2022 or 2023 and did a bunch of utility work and paving. So it wasn't an issue then. They did a good job with the concrete in front of it. They were able to keep the existing apron at the grade it was and do the road repairs without having to damage it.
What is the pipe project?
You did a sanitary sewer repair with MSP, I believe, followed up by paving with BlackRock. I was involved with that. You can hear how these.
In the water.
Yeah.
I'm
Yeah,
sure
usually
you
before they,
understand.
anytime before you do a road improvement, you ask the utility guys to come in to fix up this stuff because you're gonna be on the moratorium.
So kind of answer the question I was asking, like, what is the rationale, why the town, the rationale for the town require concrete? It's just a cost liability and that's it?
I mean, you could use cheaper, but asphalt would look bad, concrete would be looking a little nicer. Some paver stones could get very pricey. So say you had to come in here and raise the road up 2 inches and you ripped out these paver stones, sometimes it's a problem to residents that you're damaging something that they put in that costs quite a bit of money compared to a concrete, which is a pretty standard, where you could replace everything and make it kind of uniform and for a reasonable price.
That's an interesting comment based upon the use of artificial turf in that planting strip, because we had numerous complaints after snow plowing that you damaged my artificial turf, which is why it's not in the ordinance, because it's more expensive than just putting down seed.
And I think that there's also an issue, Michael, maybe you can help provide some clarity from an engineering standpoint as well, but, you know, pavers, often when you set those, there's different gradation of pavers for strength, and we don't know what those pavers are. Some are for patios, and some are for vehicular traffic, and so there is a difference between the types of pavers. And so did any? So
I
that-
tried to get the paver information from them, and sometimes they set them in concrete with bases, sometimes it's over sand. If it's set in concrete, it's harder to replace, whereas sand, you can pull them out and put them in there. While I don't have the paver material, these do look like the driveway pavers. I've
Okay.
seen quite a bit of them, that I had no concern with them being a lesser paver.
Because the other issue is if you're turning up, that's in a heavy wheel turning movement and that apron. And that's the other reason for concrete, is that pavers shift if they're not put in and set in concrete, especially along the edges, and you have vehicles turning over time, you'll see separation of those pavers breaking apart, pushing out into the lawn. And so, you know, there is that concern from a maintenance standpoint.
Yes.
And based on the structural integrity of what was built.
Well, one way to alleviate that concern was this was put in 6 years ago. I have been out there to check at it, and there was no settlement or any movement in the pavers, so it does indicate that they've used the proper pavers, because if they would have put an inferior product in, after 6, 7 years, you would probably start to see the ruts and the wear and tear from that.
And changing the perimeter pattern actually helps with the stability of that driveway, because they did put the blocks around the edge to help transfer that load. The other issue that I see is, because we have 2 different driveways, that means we would have to do 2 variances, so would the other homeowner have to come in and apply for a variance as well for that driveway? And how could we approve one without actually knowing what we're gonna do with the other? And how does that procedurally, how do we do that? If we were to consider doing that, what are the ramifications of that? And then, how do we know if those pavers are they separated by pattern between the 2 driveways?
No.
Or is it a continuous pattern all the way
Yes,
through?
it's uniform.
So how do we, if one homeowner doesn't want to fix it, and the other one does, and we have this problem potentially of this unified apron on our property.
I think they have the same problem with concrete.
Well, no, the concrete's concrete.
Concrete cracks on one side, somebody doesn't want to fix it.
Well,
You know,
but then
they
this-
have the same argument.
But even at that width, you usually would have a divider down the middle, because it would be
You have a
too big
joint
to
right
not have a
there.
joint for.
you know, the expansion joint between the two, and then you have separate driveway aprons because of the joint.
The one thing I would recommend for this, that'd be the easiest solution, though, would be, as a condition of approval, if approved, if any sort of repairs have to be done by the town, they're only liable to put concrete in. Instead of having to just destroy a perfectly good apron to put concrete in, why not make that a condition?
We don't have the specifications on this, so how do we know it's perfectly good apron?
From my visual inspection, it looked like it was in good shape. I went out there, I checked the slopes.
Specification as to like, is there wire, you know,
You wouldn't put a wire with the paper, it would be the block itself would be a string.
that's just it, we don't know what's underneath. So, again, my issue is, I looked at this zoning permit, and apparently it was approved, on October 19th, 2020. It has approved, but I've never seen an approval where it's just a stamp. So I don't know who the zoning officer was, but the application makes no reference to the apron. It only references the driveway.
That's because we didn't know that the apron was not permitted. But we were told the violation that we had incurred was failure to get a permit. So we were looking to cure that, and no, despite the visual inspection of the driveway by the employee of the town, nobody said that's a problem with your apron. Like, you shouldn't have put that apron in, you should have poured concrete in. In which case, I would have made the contractor rip it out at his own cost and put in a
Yeah,
pipe.
absolutely.
But 6 years now, I don't have that contractor's retired. He's not gonna come back and fix my apron.
I'm gonna read from this, page here, it's an attachment that was submitted, and, there's a background section.
Yep.
I don't know if this is A1 or A2, how do you want it?
Is that part of the
It's
application?
part of the application, so I just referred to it.
So I need to get to where it is in the application that I have, but if it's part of the application, it doesn't have to be marked.
Oh, okay, so I just want to
Part of
make
the
sure that,
application.
okay, it's part of the application. So, you were the owners in fee of the property, correct? So, the permits are your responsibility
Yeah,
as the owner in fee.
understood.
It's not the contractor's responsibility.
Understood.
So you admit right here that it was the contractor's responsibility.
Well, we had asked him to make sure he knew what contract permits. I'm not putting the liability on him. I own the liability. I'm not here to tell you I did it all perfect and we got the right permit. In fact, I'm telling you, we didn't get the permit. And so when we figured out that we needed a permit, we said, mea culpa, like, what can we do to fix that? And the Borough of Bradley Beach employee said, go get a permit. And so we got the permit. And that was the last we heard about it.
And that was the last year. See,
So can I just add, so I have received the zoning office's file on this, and there are, let me just see, there are 3 or 4 permits here, and there is a permit for the driveway. It's issued on 10/19/2020.
Yeah,
So,
that's
but it
exhibit-
is,
that's
it
exhibit
is.
B that we have.
Right, and it is, as Ms. Dover says, it's after the fact. But the current inspector that issued the violation indicated that it was approved for concrete. And there is a survey dated 9/4/2018, now that's before the purchase, but it's after the date of this application. So presumably this 9/18/2018 survey was handed in at the time.
So we didn't submit that. That's I don't know how that came into the file. That is,
I requested it, we sent it.
yeah, that.
Okay, but this
That is the original survey of the property
Okay.
that when we purchased it.
Yes, I understand, but it's marked with the received mark, 10/19/2020 by the Community Development
They
Office.
must have asked for it, but it wasn't intended to.
Well, it's part of the
But, okay.
submission of a zoning permit, you have to submit the survey to show where the work is taking place.
Right, so it says concrete, it's
But
circled.
that's what was there at the
Actually, the existing apron was asphalt, so the survey would be wrong if it showed it as concrete.
This is the original survey, like, that
This is-
we were asked to submit. This isn't something we created as part of this application.
This is the survey they got when they purchased the property.
Correct.
Okay, in 2018, I thought you purchased it.
2020.
Well, the date of it is 2018.
Wonderful, but I bought the house in 2020.
And so you used an old survey when you purchased the house? You didn't do, okay, so,
The apron was concrete at that time.
Yeah,
In the
survey
picture, it
reflects
shows
the
No,
the
she
picture.
showed, I thought we had, where's the picture of the old apron?
Picture
I
shows
sworn I
the
saw an asphalt.
No, driveway,
No, there's-
asphalt.
That's the original driveway.
You don't see, but this is the sidewalk, this is the apron.
Right.
It's actually asphalt. I'm sorry, the picture doesn't show it. I went on Google Earth to look at the
Oh,
old
okay.
images. There was an asphalt apron that was in very poor shape. That's the sidewalk in front of the apron driveway.
But this, the survey dated 9/18/18 reflects.
concrete.
That would be wrong. I saw the visual image of a street view showing asphalt before the repair.
Just to clarify, the house was a disaster.
This is not the apron, this is the.
It was a flip job. So I don't know what happened in 2018. It was essentially like a tenement building. I tried to explain to you the condition of the house. Somebody came in and flipped it. That's what it looked like. That's the contemporaneous photo of, as of July 1st, 2020, when we purchased the property. I don't know what any survey said.
So the current inspector issued it because he believed that back then, a concrete driveway was approved. He circled the concrete driveway on this 2018 plan. No, actually, I shouldn't say he circled. I have no idea who circled it. It doesn't really matter. All I'm saying to you for these purposes is that there was a driveway permit that was issued, but it was done after the fact. So whatever happened, it happened without a permit, and then later on, they went and got a permit, that has been testified to.
And the driveway is on their property.
The
The
driveway,
apron is not.
well, the apron that currently exists is, we have a photo of it, or we saw it before, that the apron, there it is. So that's what was put in by the applicants for both driveways. Now, let me just say a word about the
Can I
driveways.
just clarify? The owner of the White House, we went to him and said, we're gonna repave our driveway. Do you want in on the paving? Because your driveway looks a little bit beat up as well.
Yeah.
He declined, but he said, oh, I'll do the apron. I don't know
Okay.
why? Because it was asphalt. I don't know, it was probably in the worst possible repair out of all three components, sidewalk, apron, and driveway. So we jointly paid for it and had the contractor do that together, so just to clarify.
So then, from there, and from what we've heard from both our board engineer and the applicants, what we are faced with is a non-conforming apron that's been installed. And the chair is right, and others are right in questioning, is it as strong as if they had followed the requirements for concrete? We don't know. What we do know is our opinion of our engineer, who inspected recently, right?
Yes.
Since this was, and you
When
did
I
a
got the
report.
application, I re-inspected it.
Yeah, and you did a report as well,
Meets all
that
ADA requirements.
there is no, and the main purpose for those concrete driveways with the reinforcement is, in fact, that there's often deterioration with pavers. But we have testimony from our board engineer that it's, after 6 years, there is not any indication, or there's little indication, or no indication.
I have seen absolutely no settlement, it's in great shape. The pavers, the colors are holding up, there's no settlement, no cracks. Like I said, all the slopes meet the proper requirements for ADA and driveway slopes as well.
So, the point that is made in the board engineer and planner's report that was recently issued, and you got a copy of that report, correct? So, obviously, if there has to be a municipal project where aprons are being taken out of that property, we are not putting aprons, we are not putting aprons back in. We would have no obligation to do aprons. We would do the standard concrete that would be required, or we would not allow you to have the pavers if that happens. So, obviously, that would be something that would be a condition of this board should there be an approval. If there is a denial of this, then that would result in the violation being probably upheld in the municipal court, and these applicants would probably have to tear that driveway up. Like, also, the apron, and also the neighbor would have to do that. Now, the neighbor, we know from the last meeting, the neighbor got issued a violation, and somehow it's been held in abeyance, even though the neighbor has not yet filed. And to the earlier question, these applicants are doing the right thing and being filed here. The other applicant, the other owner, will or should be directed that we're gonna proceed with the violation unless you file for the appropriate relief. And frankly, it would mean if we gave it to one side, we'd probably give it to the other.
So matter of procedure, so theoretically, if we did agree with the engineer and allow that to stay, and there's not
With conditions.
Conditions, and there isn't, the other applicant, the other resident never comes in and does it, I mean, we would have to put a condition that this would only be approved if in fact the other variance was obtained, or no?
Yeah, I don't think that the board has the jurisdiction to hold these applicants back from an approval that they appropriately applied for because the other didn't apply. They don't control that neighbor.
True.
Obviously.
But that driveway being intricate, the structural,
Yeah.
than the concrete, those pavers are a herringbone pattern across the property line.
Yeah.
And so they're basically, it's actually one continuous driveway apron.
And I just was also going to say to you, I'm looking at the survey that I have from 2018, but I thought that we had a more recent, maybe we don't have a
No,
recent.
that was different.
So I cannot opine at this moment, excuse me, one person at a time for the record, please. I cannot opine if legally this is not a shared driveway. It appears to be a shared driveway because they don't appear to be, I don't know, width-wise, Mike, do you know the width of the two different driveways? Or are they
Not
different?
off the top of my head, but it's conforming. The width is perfectly,
You would think that
they're
they,
about 10.5 feet.
they're not a shared driveway. I had a shared driveway and the driveway was split. The middle of the driveway was on the property.
Yeah,
This has.
Yeah.
This is not the case.
Yeah.
We each have a
fence, now
driveway
you
on
have
our
the
property.
pavers delineating two separate driveways. It just seems like just a shared apron. Well, it's a curb, it's like a pavers, Belgian block curb, I'm sorry.
Okay.
That's what I meant to say.
yes.
You just
we
put
see
that in so that when people pull in, they know which side to park
Yeah,
on,
yeah.
so we don't park between the
Don't
two.
park on.
Like, we don't park, somebody comes visit, parks in the middle.
Yeah, so from a legal perspective, it appears to be not a shared driveway. And the applicant and their neighbors are treating it as not a shared driveway. And if they are both appropriately sized, then the point is, they both have the driveway to use,
Excuse me?
independent of the other.
Emery, your contention is these are two separate driveways. And so, but it doesn't conform with the setbacks off the property line, because it was probably intentionally built as a shared driveway, under the ordinance of a shared driveway. Now you're saying it's two separate driveways. Both driveways are not following any of the variance for the setback off the property line.
Is that true? I just asked you
It
that.
does not meet the setback. What I'm
Right,
saying
if
is
you're
they're
calling it a
divided.
separate driveway.
It had, when they bought the house, there was a fence dividing the two sides.
It doesn't matter.
And now they have a curb line going down the middle to kind of delineate the two. I agree that it does not meet the setback requirements.
But
was
that's what I'm
previously
saying,
mentioned.
for definitions, I think, I don't wanna get too far off
Yeah.
track.
Yeah.
But I think it still should be called a shared driveway. The fact that they put Belgian blocks on the side is just a delineation.
Yeah.
Does it even matter because?
Yeah, it does, because now we have to-
But the apron is not shared because they don't own the apron. That's a
No, no,
right of way.
because my neighbor across the street has a shared driveway also. And it's one shared apron, shared driveway, and it's a wide driveway. And shared driveway's a shared driveway, or the old fashioned ones where you divvy, they're 10
Is that
feet
a
down the
shared
middle, and
driveway?
5 and 5.
As
It is a
well?
shared
This is not,
garage.
but this is not.
4 bays in the garage, we have one, our neighbor has two, and the neighbor behind us has the.
Okay,
It's
so it's
shared.
like a
Three
shared.
people,
It's a
yeah.
shared structure, yes.
Right,
I
so
just,
why not a
I think we
shared
should keep calling it
Yeah.
shared driveway,
So I
so we don't
think-
open up other.
I think that it is a shared driveway that they have delineated the property.
That's all they've done, is delineate, they think it's spray paint, just draw a line down it.
Right.
I would disagree for two reasons. First of all, there was no setback on the driveways when these houses were built. The applicant had every right to resurface the old driveway, which is what they did. But the survey does not reflect the shared driveway at all. So to hold them to modern standard for a variance for setback of the driveway is silly because it's pre-existing non-conforming.
I agree with you in that case, but it's still a shared driveway.
Yeah.
And you start trying to say two separate driveways, I know what that says,
Yeah.
It is two separate driveways.
well, it's two separate driveways, and now
Well,
it's a.
but how does
But they're only here for the apron
Correct,
today.
but that
Right.
exists now.
And for all intents and purposes, I'm not going to sit here and opine one way or the other.
I prefer
I
you
don't,
don't on that one.
I don't think it makes a difference to what we're here
I
to
agree.
decide,
I agree.
which is whether or not the pavers stay as in the apron.
But down the line, in case something, because obviously it seems like maybe a little disconnect between two neighbors in some respect, but the driveways and shared driveways. Because usually when you have people with shared driveways, they approach it as one entity and fix it at once.
Yes, but obviously, there is a habit, because there was a fence before in the
Yes, there
middle,
was.
that these two properties did not treat them as shared.
Well,
Hold on.
if you knew what was there in that house before, as the applicant has alluded to, it was a two-family, sometimes quasi three-family on that street with people squatting in that house. The place was a dump.
Okay.
That's all I can say.
You've seen it, you saw it, we never saw it that
I
way.
knew the people who lived there.
We used to sit on the porch the first week we bought the house, people would come by and thank us.
Really?
Maybe you were one of them.
I may have. It was a dump.
So, and again, if I was to tasked with deciding or looking at that, I'd ask them for their title, I'd ask the title for the other, and I'd look at the title as it went back.
It's going too deep in the weeds.
Right, and it's not, it's
You're
not
only
necessary.
here today to
Yeah.
decide whether or not they get to keep the apron.
If I may,
Yes.
I just need some proofs as to the hardship.
Yeah.
I'm not seeing the hardship in this application, so.
I mean, the hardship, it's gonna cost us thousands of dollars to get somebody to come and rip out a perfectly good driveway for no good kind of community reason. It's not causing community harm, it's foundationally sound, it doesn't cause a safety issue.
So,
I mean,
if
just
you,
to-
I'm sorry,
Yeah.
can I interject for a minute? So
This is the planner.
Perhaps the C1 criteria is not the appropriate criteria here. You know, there is no irregularities, of the lot, but for the apron is on two properties, right? I think the C2 criteria might be better, you know, this is a better zoning alternative. I think, the positives outweigh the benefits. I think that in this instance, you know, the apron is already there. If you were to make them remove it, it would cause, you know, a significant amount, or at least the amount of material they need to remove. That would be wasteful. It would not be promoting the borough's, you know, sustainability goals, things of that nature. I think, the engineer's suggestion that, as a condition of any approval, they, would take no exception to replacing it with, concrete, if that time comes, if the borough needs to replace it at all. You know, that negates the detriments that, approving this
Well,
variance.
at the previous meeting, I asked about a cost benefit analysis on this. I believe you've given some numbers already. But now the other applicant has to come in, and there's been no testimony as to what it would cost to make it comply with the ordinance. And again, it's not their property, it's the borough property. And if we're gonna say it's a superior design standard, the next person can come in and say, hey, I want.
I don't think it's
I
a
didn't claim it
superior
was superior, I
design.
said it was equal,
Okay.
of strength. There was no, issues with the strength of these pavers for an automobile.
But I have the same concern. I mean, we approve it as a C2, it's simplifying, but aesthetically more pleasing than the concrete. And the next person and the next person.
I think,
that wants to do
so
theirs
every,
can claim the same
every
thing.
application stands on its own merit. In this instance, you're approving something that is already there, that they did receive a permit for, but after the fact, they have acknowledged that. If someone was to come in seeking a variance for a new, paver apron before they put it in, I think that would be a different situation than it already being there.
But maybe
Well,
the
that's-
same person could do the same thing and do it without the approval, and then come to the same house.
Yes, but that's the problem, this is a self-created hardship. So the way around it is, oh, well, you know what, I'll, instead of asking for permission, I'll ask forgiveness. And so that's the precedent that we're setting,
To
so.
me,
yeah.
if I might, if.
My sworn testimony is that we didn't do that, so.
But also, if I might, when it was brought up at the time, we followed the steps that they had said it was unacceptable, we would have changed it right away. We had the contractor, he would have paid for it, and we wouldn't be here. So, this is now coming up, we did do what they said after the fact right away, and now we're 6 years in.
Chairman, I think we can cover ourselves on that, on your point or your question, is the fact that this is 6 years ago.
Right.
And now it's coming back. If somebody comes in and says, I want to put a paver, make no illusions or do not intimate that this is a superior or better or more pleasing. It just is what it is. And accept it as what it is. It was a mistake made, we don't know by who, testimony is not clear on that. It's not really clear, because we don't know who talked about what 6 years ago. We don't know any of the conversations. We're trying to recollect. The applicant says you talk to your contractor, he's supposed to check it out, he didn't do it, whatever. It's 6 years now, and if this was done last month, I would agree with you. Somebody ripped it up and put pavers in 6 months ago, even a year ago, I'd say rip it out and replace it. You knew better. And if you didn't, you should have. But this is 6 years ago. I think it's unfortunate. My first instinct was no. But looks like stamped concrete, and our engineering report says, our engineer says, it's strong, it's an equivalency to concrete. And at the time, and we put the caveat in, hey, town needs to rip it up, move it we're not putting it back, you're putting concrete on it.
Well, you could, depending on how they said it, you could reset the pavers too. Sometimes it's cheaper for a minor repair to pull a few stones out and put them back in, but that would be the town's choice at the time. It doesn't have to be concrete if the town doesn't want.
So they say, no, we're not doing it, well.
I don't want to say it has to be replaced with concrete, because sometimes you could pull maybe a 1 yard of stones out to make a repair and put them back in, and that'd be much cheaper than getting a concrete crew in to put a new apron in.
If the board chooses to act favorably on this, I would also, the other, their adjoining property, you can't tie their approval to that, but the other property needs to come in and get the variance relief as well.
And we don't be heavy-handed about this. To make people rip, at this point in time, to make them rip it up, and you put a number on it, it's gonna cost probably $3,000-4,000 to do it. That's a big area to rip it up, prep it. Concrete's very expensive per square yard. So, it doesn't make sense.
It's up to the applicant, that's why I asked.
No, it's up to us to say, it's up to us. We're the ones that say yes or no.
So, I have a question. If minor maintenance is required, some of those blocks dance, who's responsible for that?
Well, if the block starts settling, if it's not, that would usually mean it's not, has a concrete base. And that would just require removing the blocks, putting a new base, and settling them down. And that would probably be the homeowner's responsibility. Or we could put, I don't know the town's rules, but I think we should probably put a stipulation in that any maintenance would be up to the resident for it.
And then if snowplow comes by, hits that block, and they knock them out, whereas a concrete dry apron, you never have that issue.
I
Haven't
about
had that
just
issue yet
this
either.
So I'm just-
specific situation. Like, I know these are a lot of, like, examples of all the reasons why we shouldn't have neighbors in driveways, so that's correct. And to the point, we put all that into some kind of agreement with the town, but the problem here is not the applicant, which nobody is saying. This is not the applicant. This is the town's dysfunction that's being risen up by the application, by the citation. Like, that's the problem here. Then nobody is saying this.
The process.
You're saying
It's the
that
process. I'm
6 years
saying the
ago.
problem
6 years
is,
ago.
these two people did their due diligence after the fact to remediate the issue that they knew about, and the information that they were given, they used that information to be compliant with the town's rules. That's what they did. They did everything they could do. They paid money. Now we have them pay $5,000 to sit here, to be shamed and insulted, and have these teachable moments. So it's just like, I don't know that I agree with the fact that we're gonna bring up all of these other things and make them pay for this. And that is I feel like this is a big missing piece of the conversation. I agree with a lot of the conversations happening, but I also think we should be a little reasonable about what we're doing to our residents. This is the second time we've had people come in retroactively. 13 years, 6 years, there needs to be some liability on the town. That's what
I'm gonna agree with Lauren on that as well, and just saying with regards to the letters that people are getting when it comes to infractions, no one is signing them. Just like they weren't signed by Ben, and when someone says, and they have a permit that was passed October 19th of 2020. So they actually have something that sufficed, they did the right thing, they went to the town. As for the town, with regards to when they're issuing a citation, someone, as an adult, should sign their name and signature and date as to who's actually issuing or checking it. And that's what the town is not doing. But you cannot blame them. That is something that has to be done internally with its administration with regards to the code enforcement. So pony up there and let them be. I have to tell you, I don't think it's fair. They say the integrity is good, they've lived with it for 6 years, it's pretty, and if it has to be replaced, if it's damaged or whatnot, they will go back to concrete like everyone else.
And I think the only reason that these scenarios matter is so that we can see what stipulations to put in there. If in fact we were to approve it, we need to understand under what conditions would that happen. And being that that apron is shared, that created some question into how does that happen. And so I agree with you guys that, 6 years is like, oh my God, 6 years ago, what was this town doing? And, but the bottom line is now we have a situation that we've inherited, we'll get this all right. And, it's, and under what variance qualification can we do that under that protects us for future people coming back after the fact, whether it's a year, 6 months, how do you define that? You can't. And so this is an unusual situation, very unfortunate situation, no question about it.
Yeah, and let me also just, not correct, or comment on Saracen's statements. So there is no liability for the borough after the fact seeking to determine that a violation exists and then acting on it. That's the law, pretty much. Whether it's 6 months, 6 years, or whatever, bringing the violation forward is part of what our inspectors are expected to do. The disconnect comes with when we look at these older records and we find out that things aren't signed and things weren't looked at, and you can't hold that against the applicants, but the applicants themselves, yes, they did what they thought they were supposed to do by going to get the permit after the fact. And that just obtaining the permit was a checked box, when in fact, no one told them then, but you put something in that we didn't improve. Now they're telling them. So there is no liability to any municipality to enforce the existing regulations and have it become a public meeting and then a public resolution with conditions. and you know, I generally write the conditions fairly specifically so that we have an idea of when things have to be imposed, because we are, if we do vote to grant the variance, and what I'm seeing here is you know, if there is a vote to grant it, what's going to be in there is a condition that if there is any damage to the, damage or maintenance repair that needs to be made to the apron, it is the responsibility of both the applicants here and the other property owner to repair that in a feasible way and in a timely way. Do I sit there and define every possible event that could happen? No, I don't. If the town came and paved something and paved over this, there would be something wrong, but for the town doing that? It's not for us to decide all those factors. You can't possibly decide that. But I can certainly put conditions that, you know, and the factual testimony that we've heard, it's 6 years, it's holding up, there has not been any indication that repairs or maintenance are necessary or have not been done. I mean, you could ask the applicants, have you had any damage or repair to this since it was installed?
No.
And it's only the apron, it's not the entire driveway. Sometimes the pavers really look nasty, you know, if it's a whole driveway and it is not maintained. So there would be a maintenance condition, and there would be based upon the report that we have from the board engineer, there would be a condition that if the town has to dig this up, we are not on the hook for paying for more than what would be necessary. And more than what would be necessary would be concrete. And you know, I think both of them are understanding. And I also don't know what the town's habit is. If we do that down the whole street and they're all pavers, and all those homeowners want to put their pavers back, do we say, no, go get a variance? I doubt it. I don't see why you would do a whole street of homeowners and telling them they must have the concrete when they were enjoying pavers, which may have been permissible when they put them in, right?
If I may.
But we're going far afield.
Okay, we are.
Yes.
Let's come back to here.
Yeah.
This starts because, you know, there's blaming of the town.
Yeah.
This starts because no building permit was taken. Then, when the building permit was taken, the one October 19th, 2020,
Yeah.
it makes no reference to the apron. It only talks about the driveway.
Yeah.
So now the town's at fault on that too? I mean, it's like, there's multiple things that took place here, and to blame it on the contractor when you're the owner and fee, I think you can't blame it on the town. So that's where I am, and I haven't heard, and my colleague had mentioned, self-created hardship. I mean, it is a self-created hardship. You didn't follow up with your contractor. That was your error.
And I'm not trying to take away the fact that as a homeowner, we are responsible for that. I was just trying to give you some context about how we ended up in this predicament. He had sought permits for everything else, go scour the building codes. We're working collaboratively with the contractor. He's a professional. I'm not trying to put the blame on him. I'm just trying to give you the context of how we missed this particular permitting requirement and why we had to get it some 20 days later after the work was done, and actually the borough inspector had already seen the final product. So it's not anyone's fault but ours, but that's the context. And I shared it with you to explain how we ended up in that predicament in good faith. I do appreciate that there is perhaps people who live here who think it's better to ask for forgiveness than permission. That was never our intent. That's not what the record shows. We always sought the permits we needed to do the trying.
That you were trying to skate the ordinance by.
No. Sorry.
Mr. Do you have any other submissions or any other?
No, we do not.
Do I have any other questions from the board members?
Just general curiosity, why did you decide to go paver instead of concrete?
To be honest, I think it was like
It probably wasn't cheaper at that point.
No, we weren't trying to be cheap. We
So-
wanted it to look nice, and I think the contractor was like, hey, it might be beautiful to put paper. We decided that was too expensive. And he said, well, maybe a good compromise is we make a beautiful apron. And we were like, that sounds great.
He had and they don't, he had no discussion of, you know, I don't know if this is legal or not.
Not at all. If we had had any discussion like that, we would have cleared that, we would have clearly just said, put in concrete, because it was cheaper.
And who will decide, like, because shift does happen?
Yes.
You know, if one block, it comes up a little bit, who's gonna decide, well, that has to be fixed now, as opposed to waiting till, one block?
Part of, I mean, it may be in the borough right away, but they put it in bulk destruction of something. And it's caused by a dump truck owned by the borough. They probably will sue the borough again, unless the borough willingly says, okay, we'll fix it for you, because we hit, it's like they hit their mailbox when there's a snow pile. We get it, but I don't think that we need to belabor the point on it. Maintenance,